Would you bar, which means forbid, okay? I was born in Louisiana, raised in Arkansas, so I told them, put them in one syllable words for me. So would you bar defendants from open pleas before a judge if a plea agreement cannot be reached? Or would you reserve the right to object if you thought the judge might be more lenient than the plea offer was? In other words, what you're willing to give them, if you thought the judge might be more lenient, would you reserve the right to object? I don't even know if you can do that. And which level of prosecutors in the office would be allowed to make that decision?
Yes, and just to educate you a little bit, if you
Please.
don't
Please.
know, the way that it works is there's a guilt-innocent phase and then there's a punishment phase, what's called a bifurcated trial. And so, first of all, you can choose a jury or a judge as a defendant or defense attorney for the guilt-innocence, and the same for punishment. And if the defendant chooses a bench trial, which would be a trial before the court, and the district attorney does not agree, they can force a defendant before the jury by law. And they can do that for either the guilt-innocence phase of the trial, or they can do it for the punishment phase of the trial. So the question, I believe, is that if a defendant would like to exercise his right to go before the judge, but I felt like that judge would be too friendly on the defendant, would I have a prosecutor exercise their ability to say no to that and force a defendant to trial? And my answer is no, not in Denton County. I know each one of our district courts as well as our misdemeanor courts, and you guys have done great work in electing great people to those offices. And if that would be a defendant's election, then I would certainly honor that and believe that our judges would administer justice in a fine way. But certainly if I believe that a jury would have done something different or something better, then I would not cause any type of, or cause the defendant to go before the jury, because I think that our judges do a fine job in that way, and I would trust them to make that decision.
Paul?
We don't have a quota system. We don't have prosecutors playing games one way or the other. When you charge somebody, either be it by misdemeanor or a felony, we let the defendant choose that and their attorneys. We don't step in there and say, hey, we're going to do it this way or that. A defendant can elect at punishment if they go to a jury for guilt innocence. The defendant has the sole right to elect to go to either a judge for sentencing. We can't step in there and say one way or the other. Again, we bring the charges. We don't sit there and try to play fast and loose and see what we can do, because my job and my prosecutor's job is to seek justice.
Hank?
First, I'd like to point out that there is no guilt or innocence phase in any criminal trial in Texas. There's a guilty or not guilty phase. If a person, that's where the jury is always asked to return a verdict on, is someone guilty or not guilty. If they were innocent and the system works perfectly, they wouldn't be there anyway, right? The state always has the option to force a jury trial if they want to. I think it's foolish, because I've had that happen to me as a defense attorney before, that they said, by gosh, we're gonna force you to have a jury trial. We don't want you to have an open plea. Well, the way you remedy that, if you have any experience, is you say, walk out there to the voir dire and you say, I'll take any 12 of y'all in a felony, or any 6 of y'all, and sit down. And then you get up and say, I'm sorry that you've had to be here, but we're going to the judge for punishment. And that usually will break the district attorney's office from sucking that particular egg.